Our moderator today is Chris Crutchfield. Mr. Crutchfield is the Deputy Director for Community Relations and External Affairs at the Ramsey County Community Corrections Department. Mr. Crutchfield is also an adjunct faculty member at St. Cloud State University, where he teaches media law and ethics in the Mass Communications Department. Prior to joining Ramsey County in 2006, Chris was a partner at Capitol Heights Law Group, where he litigated and counseled small business and nonprofit clients. During his time there, he was also lead counsel for one of the largest gender-based discrimination settlements in Minnesota. Please join me in welcoming Chris Crutchfield.
Good afternoon, everyone. I am so happy and thrilled to be here at the role of the legal system in shaping African American life. We are in Hallett Halls, where this courtroom has seen many great lawyers and many great trials, and I'm hoping to have an excellent discussion with really some living legends. And I am very excited to introduce them both. Oh, I'm sorry, all three of them. I'm sorry. I'm a little nervous. Panelist Japal Harris began his service with the St. Paul Human Rights and Equal Opportunity Commission in February 2007. In 2010, Merrill Coleman appointed him as chair of the commission. He is an active member of the legal community, including the Ramsey County Bar Association, the Minnesota Association of Black Lawyers, and the Minnesota State Bar Association. Previously, Japal worked as supervising attorney of the Senior Law Project at the Legal Aid Society in Minneapolis and at the Minneapolis Public School District, and as staff attorney at the Southern Minnesota Regional Legal Services, Inc., in its Housing and Equal Law Project. Currently, he is a referee in Hennepin County. He lives in St. Paul's North End, where he is also known for coaching youth football at Jimmy Lee Recreation Center. Please welcome Mr. Harris. Our next panelist is Judge Pamela Alexander. The Honorable Pamela Alexander was reappointed to the Hennepin County District Court in 2013 by Governor Mark Dayton after serving 5 years as president of the Minnesota Council on Crime and Justice, the third president in its 55-year history. Judge Alexander was originally appointed to the bench by Governor Rudy Perpich in 1983, making her the very first African-American woman judge in the state of Minnesota. She has presided over cases in the criminal, civil, family, and juvenile divisions of the court, having been the presiding judge in the juvenile division and the assistant chief judge of the court as whole. Judge Alexander is currently the presiding judge of the property drug team, where she has administrative duties as well as handles a full caseload. Please welcome Judge Alexander. And finally, panelist, Judge George Stephenson. Judge Stephenson practiced in 17 years. Judge Stephenson has practiced for the past 17 years in the areas of prosecution as deputy city attorney and federal defender in Chicago, and was in private practice focusing on defense work, child protection, and delinquency, before being appointed and now having served 13 years on the bench in Ramsey County. Panelist George Stephenson. We were next scheduled to have a performance by Brotherhood Inc., but unfortunately the performer has fallen ill, so we can jump right into the panel discussion. Before we get into the questions, I'd like to give the panelists just a few minutes to introduce themselves. So we can start with Mr. Harris.
Well, again, I'm Japal Harris. As was earlier said, I am a referee in Hennepin County. In this position, I preside over housing court, mental health court, as well as some petty misdemeanor matters. So the focus of my understanding is more around the civil aspect, and I hope to bring that part of the justice system to this discussion. So as also said, prior to that, I did practice civil rights law, mostly in housing discrimination at Smurls, as well as over at the Legal Aid Society of Minneapolis. So I'm happy to be here. If you mess up and call me Judge Lang, I won't be mad at you. I am sitting in. I will just understand that. So again, thank you for having me here.
Good afternoon, I'm Judge Pamela Alexander. I think he's told you pretty much about my history. Had I stayed a judge since my first appointment, this would be my 32nd year, but instead it's my 27th year as a judge. Prior to being a judge, I was a prosecutor in Hennepin County, specializing in sexual assault cases involving children. Prior to that, I was a defense lawyer for a number of years, defending everything from parking tickets to first-degree murder cases. Prior to that, I was a bank lawyer. You're probably saying, what is wrong with this woman? Anyway, I was a bank lawyer prior to that, and didn't really like that job a lot, but did meet my husband there. Then I immediately quit and got into the criminal law, which is what I wanted to do in the first place. I'm happy to be here with you this afternoon and hope that I can shed some light on some of these issues for you.
Good afternoon. I'm Judge George Stephenson. I think I'm the only judge in Ramsey County that stands all the time during court, so it's a little bit uncomfortable for me to be sitting. I like to stand because I like to see everybody that I'm talking to and to see what's going on in the courtroom. I've been on the Ramsey County bench for 13 years. I am currently the Assistant Chief Judge. I am just transitioning from a criminal assignment to civil commitments and probate. Most of my work during the 13 years has involved criminal and or juvenile cases. I would say that much of my experience, probably my most valued experience on the bench has been some of the extracurriculars I've been involved in, which includes a men's group for felons who are on probation that meet with me every other Wednesday for a couple of hours, and the goal is to get those guys back into the community as law-abiding, contributing members. But I'm glad to be here this afternoon.
Before we get started, if I could just take a minute, I wanted to tell a quick story because the Twin Cities is just a small community. And as I was thinking about the panelists, I thought about one of my very first times in a courtroom. And I was in front of Judge Alexander. And I remember I was outside the courtroom and I was so nervous and I was sweating. And I was very, very nervous. And my client said, "Chris, you're so nervous." I said, "Well, I'm in front of Judge Alexander and I've always admired her and I want to get everything right." And he said, "Chris, it's an adoption." But she was so kind and with everyone involved. And that, the humanity which all three panelists bring, because they're all excellent attorneys, they've been excellent judges, but at the same time, their deep commitment to the well-being of the people in our community, specifically people of color, has really stood them out, and I'm just really proud to be the moderator today. So let's just jump right into it. Question number 1 deals with the 13th Amendment. Common understanding is that the 13th Amendment made slavery illegal in the United States, but contemporary commenters such as Douglas Blackmun in Slavery by Another Name and Michelle Alexander in The New Jim Crow argue otherwise. These commentators say that laws passed after the 13th and 14th Amendments target blacks and poor populations and subject them to a life of slavery or involuntary servitude, to use the language of the 13th Amendment. Some further argue that the 13th Amendment allows for persons convicted of crimes to be returned to a state of slavery or involuntary servitude so long as they have been duly convicted and have enjoyed the process of law. And the question is, what laws support or oppose Alexander and Blackmun's views? And I would like to start with Judge Stephenson, especially in light of some comments he made in the paper about a young man who came before him, and how the young man had made some choices that allowed him to go back into incarceration. And so, Judge, can we start with you?
Are you going to tell them what the comment was?
Judge, can I leave that to you?
Sure. It was a murder case. A young black man who shot and killed another young black man over, I believe it was $300 worth of marijuana. And the comment I made to him, which I make to a lot of young black men and some not so young who appear in my courtroom, is that when you do these things, essentially you are saying that you don't want to be a free man, that you're a slave. And there are lots of times when I ask folks who appear before me, tell me what you've learned about slavery in school. They give me a definition, and I ask them, who provides a slave with his clothes? The master. Who provides a slave with his food? The master. The bed he sleeps on? The master. Who sets a slave schedule? The master. Does that sound familiar to you? They say yes. That's what getting tangled up in the criminal justice system, being sent to prison or the workhouse or juvenile detention is. It's slavery. And you, every time you do some of the knuckle-headed things that you do, what you're telling everybody is that you're not ready to be a free man. You want to be a slave. And you can control that. And that was essentially the comment that I made to the young man that got some press. Talking about the 13th Amendment, which, for those who don't know, abolished slavery, quote, except as punishment for crime, close quote. In answer to the question, yes, there is support for Ms. Alexander's view. The New Jim Crow was the book that she wrote, and it talks about the criminal justice system and how we have, in a lot of ways, reduced the lives of young black people to slavery. There are criminal laws that offer support for that view. Here's what we do when you come into court and you're convicted of a felony. We take away your freedom. We limit your ability to travel. We take away your right to vote. We restrict your employability. There are certain jobs that you just can't get if you've got a felony on your record. You can't get them. You can't cut grass at an old folks' home. You can't shovel snow at a school if you have a felony record. We restrict where you can reside. You can't reside in public housing for certain offenses. And we restrict your ability to get educated. Financial aid can be denied to folks with certain felony records. It's slavery. And that's what we do with some of the laws, some of the collateral consequences that come with the sentences that we impose. Want to jump in and help out here? Or
Certainly.
Shall I keep going? I don't want to dominate the whole thing because I'll talk for a couple of hours about this if you let me.
What I would add is that the 13th Amendment always exempted those who are incarcerated. So if you were incarcerated, the abolition of slavery never really applied to you. So, and I think that is one thing that a lot of people don't particularly understand. So, which is how people who are in prison can work for nothing and can work for very small wages. And that's how that has been justified all these years. And so a lot of people don't have that actual view. And for all of those who keep asking me, is Michelle Alexander my daughter? No. I will claim her, but she's not my daughter. And I have met her, and she has her book, The New Jim Crow, is has a lot of very interesting commentary. The collateral consequences of a felony conviction are fairly, well, they're pretty dire. And I think when I was at the Council on Crime and Justice, one of the reasons I left the bench after serving 25 years was because of the fact that I often wondered what happened to people after they left the courtroom. I mean, I sentence them, they're gone, then I just go on to the next case. My question was, well, what happens to them? What happens to their families? What happens to everybody else after they leave? And in 2008, I started out to really look at study in depth, what are the collateral consequences of a conviction and what really happens? And is it justified? And as we were studying this very issue, it became clear that the collateral consequences were almost worse than the sentence themselves. So even though people are sentenced to prison, when they get out, they're kind of okay with doing their time, but they're not prepared for what happens to them afterward. we had a panel discussion of a number of young men who came in who had been convicted. And the one thing that they said, and there was maybe 10 or 15 of them on this panel, and they said, if we could just get past the label felon, no matter how we do, no matter how well we do, we can never get past that label. And I said, well, you know, tell me a little bit more about that. And their big issue was, even if I get a job, even if I take care of my family, even if I'm not on public assistance, that will still hold me back. And it actually really does. As we delved into it, there are jobs that you can't get. There are, you're not eligible for educational loans. The example I used to get is that you can't even shovel manure at the racetrack because we have a provision in the law that says if you are convicted of a felony, you can't work in the gaming industry in any capacity. The same with working, you can't work at a hospital because you can't be around vulnerable adults. You can't work with children because you can't be around children. So that takes out a number of avenues that people could actually become employed. Then you have to remember that the employability of a number of our convicted felons who have limited educational, they've attained probably, if a high school diploma or not at all, it becomes almost impossible for them to get into higher education at all. And so you can't get some student loans if you have a drug conviction or a felony conviction of particular kinds. So you're kind of, I think, your whole life kind of goes into second-class citizenship. And that is precisely what Michelle Alexander was talking about in the new Jim Crow. Does this equate to slavery? Not necessarily, but it certainly makes people's lives extremely hard. And so I think we need to look at what kinds of restrictions we put on people and why we're doing it. Personally, I think, yeah, if you're a convicted sex offender and you did something to children, no, you shouldn't work around kids. However, if you have a felony that's totally unrelated, you have rehabilitated yourself, there's no problem with what you're doing. If you stayed crime-free for 5 to 6 to 7 to 8 to 9, 10 years, you should be able to then work in some particular areas. And what we're doing now is putting lifetime bans on people, and that is problematic. Because the one thing that helps people not reoffend is to work. And we found that. All the studies have shown that. So if you can, there are two things that show. If you can get, you can have decent family ties and a job, you usually will remain crime-free. We do have some people who also age out of doing criminal activity as well, just because they get tired. But you know, like, whatever works, you know. You just get too old, fine, you know. But I think that if people can get a job and maintain some sort of stability in their lives, that generally will stop them from being involved in the criminal justice system. And I think that we have to really look at why we limit the people the way that we do.
And I think I will touch also on the collateral consequences. What are some of the things that make us productive citizens? Stable housing, civic engagement, a stable job. Incarceration takes those things away. And that's what makes you the slave, is that you get those things taken away. And when you come out, those things are still taken away. So let's take housing, for example. As Judge Stephenson said, there are certain crimes that if you commit them, you can't get into public housing. So if you can't get into public housing, where do you go? Well, market rate housing, right? Can you get into market rate housing if you can't get a job? No, you cannot. And you can't get a job, certain jobs, particularly dealing with children, vulnerable adults, and some others because of these crimes. So I think that's one of the big things we need to look at is the collateral consequences, because I think that's really where the slavery, if you want to say it, is at, in that you, in all of these collateral consequences, whether it being you can't vote when you get out for a certain time, whether it's here in Minnesota until you're off paper, or in other states where you just can't vote. You get committed, you commit a crime, and from the time in which you're out to the time that you're in the dirt, you can't be civically engaged. You know, these are things that make us citizens. These are things that make us want to be invested in the community, and things that if you're invested in your community, you most likely will not go back to the life that you've come from. I mean, Judge Alexander's right. Sometimes folks just get plain out tired. They're sick of going in and out. Some folks, they get those things that you need to make that decision that you no longer want to be part of that system.
You know, we were talking about collateral consequences. We've been talking about collateral consequences du jour under law. There are other collateral consequences that are not dictated by law. I've got guys in my group who have managed to get jobs. They're felons. They've managed to get jobs, stabilize their lives, doing real well. As a matter of fact, doing so well that they got promoted in their jobs after 6 months or after a year. The employer then had to do a record check. Record check revealed the felony conviction. They fired them. Now, they had done well for 6 months or a year. And this is, I'm not just talking about one or two, I'm talking about several guys during the 11 years that I've been doing this group who got fired because they did so well that they got promoted. And those are decisions that are not made, that are not dictated by law. Those are private citizens that make those decisions. They choose not to hire certain folks in certain positions. And I'm also not talking about the mad bomber, rapist, killer. I'm talking about people who had some silly drug crime, who committed a theft, who committed a felony DWI. They suffer as though they are the mad bomber, rapist, killer too. We need to make some changes in how we do business. You talked about the fact that, Judge Alexander talked about the fact that employment is a significant factor to having people restored to the community as law-abiding and contributing. In Ramsey County, we have no employment assistance program through our corrections department. We don't. So, even if you don't go to prison, let's say you get put on felony probation, you still have that scarlet F on your chest. And you suffer just like the person, the mad bomber, rapist, killer who got sent away for 20 years because you can't get that job. There's no program to assist you in getting a job. And our corrections department folks feel that employment is not that significant a factor to reducing recidivism and to remaining law-abiding. It's a fight that we've been having with them for years. I wish they'd listen to you.
I did, when I was president of the Council on Crime and Justice, we did pass some legislation. You might have heard the ban the box legislation that was passed in 2009 and again in 2011, so that if a person who was convicted of a felony did not have to write on their application, well, they do have to put on that they were convicted, but they don't have to, and once they did that, employers just never even talk to them. Now, the way the law is written, they don't have to write it on their initial application, but if they get an interview, then they can be asked about it, and they are all asked. But we also found that they had a 30% greater chance of getting hired once they got the interview. Because if people are going to let them have the interview, then they have a possibility of getting the job. So what we used to do at the council was to teach people how to talk about their felonies when they got in the interview, so that they could at least explain what had happened, give the employers an opportunity to say, okay, I understand, let them show how they've been rehabilitated up to that point, and then they can see if they have a chance to get the job. Before that, they had no chance to get the job at all. And it was passed for public employers in 2009 and private employers, I believe, in 2011 or 12. So that was passed and is now law. We also got a bill passed called the Higher Education Notification Act, which was another bill where we were concerned because people would be lucky enough to go to school, pay their own money to get loans and go to school, and then they would get in areas of study that they could never be licensed in. And that happened a lot with nurses or people who were in the healthcare field. And they would pay for all this education and then find out that they could never actually work in that field at all. So we passed the law to hopefully show them that, so that the higher education institutions would tell them, you should really pursue something else because you may not be able to work in this area before they spent the tens of thousands of dollars on their education. So that was also passed. And I think the council's doing a follow-up to make sure that the universities and colleges are doing that now. So at least in that regard, people will know before they pay a lot of money that they can get in a field where they can actually get gainful employment. So those two things were done.
After Judge Stephenson made his comments in the paper about choosing slavery, ex-public defender John Stewart actually spoke to our corrections department, and he challenged us. And he said, the judge's words are true, and where does that leave you all as systems people? So I'm speaking to the systems people in the room. Are you to act then as the overseers, or are you to act as the Underground Railroad liberators to help the people who end up in the situation get back on track? And it's really, I think, something for us systems folks to think about. And I wanted to segue into talking about Judge Stephenson and how that he had me cut out most of his long resume, his bio, but a piece that I think I should come back to is that for the last 11 years, every 2 weeks, he meets with felons and men who have been incarcerated or are coming out and works with them, trying to help them not recidivate, successfully reintegrate, and have good lives. And he does that on his own as something that he's done for 11 years every 2 weeks. So I think you can see where he stands. Moving on to the topic of voting rights. In 2013, the U.S. Supreme Court ruled that Section 4B of the Voting Rights Act was unconstitutional. And that act required, Section 4B required certain states with a history of racial discrimination in voting laws to pre-clear any proposed law change regarding voting rights with the Department of Justice or a panel of appellate judges. Right, so they don't have to do that anymore. In the wake of this decision, several states that were formally required to pre-clear their laws have passed very arguably significant voting laws. We're wondering what your views are on the effect of the Supreme Court's ruling on the Voting Rights Act in the states that were formally covered. Who would like to start?
The states that were formally covered are mostly in the Bible Belt, in mostly southern states that were covered by that requirement. Since the ruling from the Supreme Court, there have been many different requirements that have now coming up, not only in those states, but in almost every state, including Minnesota. Many of those having to do with identification requirements, which are kind of the least right now, to showing residency requirements, a lot of other things that are being kind of put back out there that were not required before. Minnesota, as you know, probably was one of the states that has the easiest way to vote ever. I mean, you know, you can register on the day, you just have to have somebody vouch for you, all of that. The reason why this is becoming a huge issue is that there are certain, in communities of color, there are certain people who are being, having to go through a lot of obstacles in order to vote. Even in Minnesota, we've seen a little bit more voter suppression than we've seen before. One of the things too is you know, people publicly asking folks, are you a convicted felon when you go in to vote, which generally doesn't happen. I've even been asked. I was like, no. There's my name. I've been voting in every election for the last, since I could vote. And they said, well, are you a convicted felon? I said, no, not today anyway. I'll kill you if you don't let me vote right now. But anyway, we're receiving a lot more complaints of people feeling like they're being asked questions that they were never asked previously. Specific communities of color being ferreted out. Like many African Americans being asked, are they convicted felons when they go in to vote? Many Hispanics really being questioned about whether they're citizens. And so we're seeing a lot more of that than we have before. Although Minnesota is still a great place to be able to vote, and usually we're really one of the states that stand out in that regard. But a lot of barriers to voting are coming up now, especially in those states who don't have to show that they're no longer discriminating, and because they have historically done that. So it's I think it's going to be a very interesting discussion in the next 2 to 3 years as to what happens in those particular states. And I think we're going to see, especially with the ID requirements, how that's going to probably morph into something else. So I do have some concern. I do know that the NAACP Legal Defense Fund is really gearing up to deal with those issues in those states right now, and I will be real interested to see where we go.
So what we know is that the demographics of the country are changing, and as such, voting patterns are changing. In the wake of the passage of the Voting Rights Act of 1958, it was passed for a simple reason. It was that these states were taking actions to suppress the vote, whether it was purging the voting record, whether it was requiring poll taxes, whether it was just flat out suppressing the vote through violence. This is what they were doing. I think that the pattern bears it out that, in wake of that Supreme Court case, a lot of these states, whether it was Florida purging their voter rolls, whether it's Alabama, Mississippi, Louisiana, South Dakota, Wisconsin, all passing some form of voter identification or some form of some voter law or laws as it relates to proving who you are to vote. So I think that I agree with Judge Alexander that it is concerning that these states, as soon as the Supreme Court told them you no longer had to get clearance from the Department of Justice, did what a lot of civil rights leaders and the NAACP and Urban League and other folks thought they would do. They passed these laws which put a barrier to voting in front of particular individuals, and due to poverty and other reasons, we know who those individuals are. They were people of color, whether it's African Americans in the Bible Belt South or whether it was Native Americans in the reservations of South Dakota. The basis usually is that it is voter fraud, yet there's not many cases, at least in Minnesota, of folks who have been convicted of voter fraud. So I don't know if the solution is really an address to a problem, or is the solution a solution to something else?
Well, it's interesting. I guess it was about 7 years ago when there seemed to be quite a stirring among some folks in some states, many states, to restrict the ability to vote. 2008. And the demographic that is most impacted by these restrictions: young people, college students, people of color, elderly people. And it's interesting that those populations disproportionately voted for one particular candidate. I don't think we need to say a whole lot more about where the political push comes from for those kinds of restrictions. You would think that if there was really a concern about voter fraud, the concern would have happened a few years earlier when we had a really close election that had to be decided ultimately by the Supreme Court. that would have been the time to really sort that out. But come on. I mean, we know what this is about. This is about parties wanting to win. And that's what we're dealing with. It was shortly after the election in 2008 that judges in Ramsey County started seeing more cases of voting-related criminal offenses brought into our courtrooms. But they were not about voter fraud, and most of them were felons who didn't know that they couldn't vote and they voted, or who knew they could vote and wanted to vote anyway. But those numbers were so small, so small. I'd say that prior to 2008, in 2008 I had been on the bench for 6 years. I don't think I had seen one such case. After 2008, after the election in 2008, I might have seen a dozen. So I just find it interesting when I hear the rationale for changing and tightening up voter registration laws.
And I can tell you, for the 25 years I was on the bench prior to 2008, I saw absolutely no voter fraud cases, not one. Since I returned from the bench in 2013, I've seen 2. Although I think they're being filed a bit more. There was just a constitutional challenge that was brought in our district that Judge Bransford just ended up ruling on, where all of them were combined, and I think there were only maybe 15 that had been charged out. So it's not something, I think this was it wasn't a problem. In most of the voter fraud cases that we've seen, and actually a couple of them have went to trial, and they've been found not guilty by juries, and it's usually because you have to show that you specifically voted knowing that you couldn't, and most of these felons go, no, I thought my rights were restored, so I wanted to vote. And I think of I did one of those trials, and this was actually a young white woman, and the jury found her not guilty. There's been several that have went to trial that have all been found not guilty, so I don't think it was a huge problem for us to begin with.
As a quick follow-up question to that, and we are running short on time, do you have any thoughts or comments on current Minnesota laws that relates to felony voting? Right now in Minnesota, a felon cannot vote while they're on probation. Once they're off paper, off probation, they're allowed to vote. Do you see for a call for any changes to that very briefly?
Well, in addition to there being a call, there are currently bills up at the legislature. I'll tell you, yesterday, a bill passed out of committee to address felon reenfranchisement. So I think there is a push at the state level at this time, primarily driven by a lot of kind of the momentum from the Black Lives Matter movements, from civil rights organizations kind of taking up the push, and other organizations like the ACLU who have those bills up at the legislature. So I do think that in the next couple of years, and hopefully this year, I do think a bill will come out of Minnesota which definitively outlines when and how felons can vote, and really kind of clarifies that issue so that in the future it can no longer be an issue, hopefully.
You know, I think it's really interesting if you know the origins of denying felons the right to vote. That started right after the 15th Amendment was passed, the right to vote, which included black folks. And once that happened, during the late 1860s and 1870s, states with larger black populations were more likely to pass more stringent laws on restricting the vote. And the reason they did it was that you're in a period of Reconstruction, and it happened mostly in the South, and folks in the South were concerned about a movement among free people, free slave black people, going to the polls and changing the status quo. And so they started doing things to restrict the opportunity for black folks to vote. Now, today, Alabama has one of the highest rates of felony disenfranchisement in the nation, about 7.2% of its citizens, but 15% of African Americans have lost the right to vote in Alabama. And if you look at other southern states, you'll find that that's what's happening. The states where there is the least, the fewest restriction on voting for felons, Maine and Vermont. They have no restrictions on voting rights for people convicted of even serious crimes, but they also have hardly any black population. So this whole thing started right after the 15th Amendment, started right in the South, 1860s, 1870s for the most part, to maintain the status quo.
We're going to be opening it up for questions in about 3 minutes, but I wanted to get to one last question, panelists, just 1 minute on this question. And it's the Pew Research Center reported in 2008 that 25% of all, that the United States has 25% of the prisoners in the world. 25%, but we are only 5% of the world's population. And that the United States has the highest, obviously, has the highest incarceration rate as well as the highest prison population. Do you have any comments on that?
Sure. I think that our prison population actually ballooned during the Reagan administration with the war on drugs. And so when there was a huge issue about the advent of crack cocaine. So that was really when the prisons really did start to balloon, at least on the federal end. And because the consequences for those particular crimes was usually incarceration and for very long periods of time. And because of that, prison populations really quadrupled, especially on the federal level, as opposed to the state level. But everybody had some sort of response to the whole advent of crack cocaine. I've spent a lot of time studying drug laws in not only Minnesota but nationwide, and there was a time where even having marijuana was a felony, and that kind of morphed over time to where it is today. But people didn't go to prison at the rates that they started to go to prison in the 80s. And so what has happened, because of the change in the drug laws, a lot more people started to be incarcerated, and which is why we have the problem that we have today. And the United States does incarcerate more people than anyone else in the world. I
would be remiss if I did not remind everyone here what we all know, and that is that Judge Alexander has not just been a hero, she's been a superhero in making sure that crack cocaine and powder cocaine got equal sentences, and that they took the racial bias out of how they were sentencing. That was enormously significant, and I think about it all the time. Thank you for that. In the 10 minutes we have left, we'd like to field some questions from the audience. Yeah?
I'm wondering is there a movement to redefine felon or to create other categories?
Not that I'm aware of. I don't think that there's a movement to redefine that, but I do think that there is some heightened awareness among individuals about how we actually treat people who have been convicted and what we can do to hopefully reintegrate them back into society. Right now, 1 in 4 Minnesotans has a criminal record, whether that's an arrest record or some sort of a record. That's a lot of people, and that does adversely affect their ability to function. And we have to keep that in mind. Now, Minnesota does incarcerate less than a lot of other states, but we do have people under correctional control at a much higher rate than most other states. And so, because we use probation a lot, we use probation and parole a lot in Minnesota, because we like to fix people here if we can. And we try real hard at that. We really try hard at that. And so, but what happens is even if if you don't go to prison, you do local time, that felon category still stays with you. And one of the things that we were able to get people to really look at too is how even arrest records stop you from being able to participate fully. We had a young man who came into the Council on Crime and Justice, wanted us to help him expunge his record. And he had been arrested for first-degree murder. Now, he didn't do it. He was the wrong person, but he could never get that off of his record. So every time he went to get a job, people said, "Oh, we're not even talking to you." And so, but he wasn't the person. So he kept saying, "I want this off my record. I want." So we went in, we got it expunged off of the regular court record. Even the BCA went as far as to get it off their record, but the private data miners already had it, and so we could not get it off of all of those because it was just too difficult to do. So we did get it expunged from the official places, but we couldn't from all the other places that was there. And it was very hard for this young man because he said, "I never did anything. I was just the wrong guy." And he really was. So arrest records can even affect you to your ability to become employed. So what we're hoping to do is raise people's awareness enough that they can say, okay, let me just take a real good look at this person, see if this is somebody that I have the skill that I may want to hire them, and try to look past it so that they can get on with their lives. We also thought that we would do, and this is another bill that was before the legislature, do certificates of rehabilitation to show that people have done well and have that with them so they can show that to employers, and that's still being talked about.
We are in the wrong political environment for something like that. Because you don't have, our laws are made by elected officials. And you don't have people running for elected office saying, let's do something that's not so harsh to people who commit crimes. Okay? We're in a law and order environment. If you can campaign on being law and order and tough on crime, then you're more likely to get elected.
And that's any party.
Right. That's right.
So basically, you won't see Judge Alexander or Judge Stephenson at their next election saying that they're soft on crime, because that's not a good idea. But I
don't have any more elections, so I may say anything.
Dave?
I wanted to ask, what was the foundation of the court's ruling, the constitutional foundation in the pre-clearance case? I know that the southern states that were affected by it had argued that, well, we've cleaned up our act now, and we're much more like Vermont. But what did the majority point to in the Constitution in declaring the law unconstitutional?
They just said it wasn't needed anymore.
Right. Enough time had passed.
And it really wasn't a constitutional, it was statutory, because it was looking at the Voter Rights Act. So what the basis of the decision was each year or every so often the Department of Justice goes back to the legislature, to the House and the Senate, and they adopt the formula for determining which communities must report to the Department of Justice in order to change their voter laws. From the passage of the Voter Rights Act until probably, I would say, the early 90s, it was a pro forma vote. You just go, it was bipartisan, virtually everyone voted for it. But as we've discussed earlier, demographics are changing and politics got into it. So it became a political issue where I believe it was in 96 or so, they didn't change the formula, or they didn't readdress the formula. So the basis of the decision was that the formula was outdated. We're not saying that you don't have the authority to do that. What we're saying is that you need to go back to the House, get that formula updated to reflect today's society, and that's when you get into the colorblind society that we have in Shangri-La, but I won't get into that. You have to go back to the House and Senate, redo the formula, get it revoted on, and then it will be okay. What we know in today's political atmosphere, the chances of getting any civil rights era bill readopted by this current House and Senate, you have a better chance of hitting the Powerball, basically. So that's really the foundation.
I think we have time for one more question. Rita, do you have a question for us?
Thank you. I'm a question dealing with law and social change. The Honorable Thurgood Marshall and Associates, through law, moved towards our civil rights that we have now. At the same time, you have Dr. Martin Luther King using the law, but also civil disobedience, all of which resulted in the landmark legislation that we have. Right now, we have tremendous disparities, particularly of people of color. You have a number of people that are using law to try to correct it. However, you also have groups such as the Occupy movement, Black Lives Matters. Today I read about 15 plus. These are people that are bringing it in a different manner. And I wonder about that whole business of law and what else needs to happen to occur for real change to happen. We've got a situation that occurred right here in the Mall of America, where you got that collision of the law and social movement.
I can't comment on the Mall of America case because that's in our court. So there's not a lot I can say about that. I will say that I'm very, for these young people that are organizing around this, I think that it's, I think it's great. I think that they really, I had been a little bit concerned about some of the erosion of the law that I'd seen over time, and I was saying, why aren't these young people mad about this? You know, because after you've worked in this for as long as some of us have, you get a little jaded and tired, and I kept thinking, these young people need to know that this is really affecting them terribly, and they need to think about what this means to their future. And so I've been very pleased with their organization around these issues. And I think it's needed, and I think their voice needs to be heard on these very, very important issues. And I'm very proud of them, actually, for trying to organize and trying to figure this out on their own. I do think that they could take a little guidance from some of us that are a little bit on the older side that have done some of this, but I also love the new energy. And I think that it's a good thing, and they need to think about how is this really affecting them. There are a lot of, I think, steps backward in the last 20, 30 years, and I'm concerned about that. And I think for a little while people thought, no, things are good. You know, like, you know, they're not as good as you think. And so you need to really stay on top of some of this and listen to some of the folks around you that are talking about these things. So I like the fact that there's organization, that people are talking. I love all this like Twitter stuff. You know, I didn't even know what that was. But I like the fact that the young people are talking, and a lot of this is something that they're getting into, the way that they communicate with one another, and I think it's a good thing. And I think it can only lead to raising people's consciousness about the issues that are still out there, that we're still fighting. We do not live in a post-racial society. We still have issues. We're still very polarized, and we need people to continue to bring those issues to the forefront.
I agree with Judge Alexander, but Rita's, to add to your point, I think there's one factor that you're missing. In addition to the legal piece and the demonstration piece, there was also a galvanizing event that occurred, whether it was the bombing at the church in Alabama, whether it was marching across the Hennepin Bridge, whether it was seeing on television for the first time diners getting their head beat in by a policeman or bitten by dogs, or a water hose turned on them. We know in the black community, some of the things that these protesters are are protesting, whether it's unfair police treatment, whether it is disparities in how African Americans are being incarcerated, these things have been happening, and they've been happening, you know, for a long time. I mean, in the 80s with the crack epidemic, that's when the number of African Americans spiked going into prison. But what we have now is we have a connected society where now everyone is seeing, you know, Eric Gardner getting choked out on the street, or they're seeing a young African American man being shot down with or without a weapon, but they're seeing the disproportionate treatment of people of color versus non-people of color. So I think that, in addition now to this galvanizing force of young people, you know, raising their voices and actually saying, wait a minute, these people, they're me and I'm these people, and you need to do something about that. In addition to lawyers and legislators starting to actually try to pass laws and from a policy perspective address it, those are the three things that are happening now that happened in the height of the civil rights movement.
I like the fact that there are so many young folks, some not so young, who are out there protesting and getting involved. For a long time, I felt we've gotten lazy as a country. We've gotten lazy. We're relying or taking for granted that somebody else is going to do our work for us, raising our kids. Well, let the teachers do it. Let the court do it. Let the neighbors do it. Policing our communities. Let the police do it. Well, you know, 40 years ago, 50 years ago, we policed our communities because you had families, you had neighborhoods, you knew if you messed up out there, the police weren't going to get called. God forbid your folks get called. Okay? We are just passing off too much to the system, to the law, to the schools. And so it's good to see folks, even though I don't agree with all the protests that I've seen over the last several months, it's good to see folks out there. It tells us, well, you know, folks are flexing their muscles, folks are using their heads, folks are using their feet, they're getting out there, they're using their voices. And we've missed that for a long time, not just in communities of color, as a nation. As a nation. And I think one of the things that has happened in the last few elections, I think we've seen a lot more people get involved, a lot more people believing that their voices can make a difference. And I think that's what we need to have happening. We need to get involved. Don't be lazy, because we have been for too long.
Well, I don't know about you, but I think we could go on for another hour or two. This has just been fantastic. Can we thank our panelists one last time?